Right. Hello, everyone. Welcome to the Greater New Haven Chamber of Commerce Small Business Webinar Series. I'm Kobe Smith, the Small Business Support Specialist here at the Greater New Haven Chamber of Commerce. And I'm excited because we have a friend and colleague of mine, Patricia DeLeo of Counsel from Brenner, Saltzman, and Wallman LLP, who's going to talk about contracting for business owners and what are the ins and outs of contracting and how it can be beneficial to those who are working in the business space. So, Trisha, I just want to say thank you for taking time to do this, and I'm excited to learn about what goes into this topic and how our business owners can take this information and apply it to their own business so they can be successful.
Right. No, I appreciate that. Thank you so much, Kobe. It's nice to see you, and it's really nice to be putting on this presentation for your small business owners. Obviously, contracts touch everyone who has a business. In some respect or another, you're going to be entering into some kind of an engagement, some kind of a contract. I'm going to share my screen in a minute and kind of just go over an outline that I prepared, but I think it's important for everybody to understand at the outset that you can enter into an oral agreement. I wouldn't recommend that you enter into an oral agreement, because what happens then is it becomes a situation when you try to prove up the agreement of he said, she said. And that can be costly and time consuming, and there's no real guarantee for an outcome there. And so I just caution people and like to let people know that you can enter into an oral agreement. So you have to be careful not to do that when you're having conversations with people. And it's really best to reduce any agreement that you have to a writing. And I'm going to go through on my outline what we like the sections and kinds of things that we commonly see in a written agreement that an attorney would recommend that you have. It's not by any means meant to be an exhaustive list, because we had like a limited time here, but it's more to give people kind of a flavor for the types of provisions that they're likely seeing if they're presented with a contract, the types of provisions that they want to try to include in their contracts. But I'm not going to cover every provision, obviously, or every different set of circumstances that could exist depending upon the differences in people's businesses. So I'm going to go ahead and just share my screen. Oh, okay. What happened? There it is. There we go. So this is just an outline that I had prepared for this webinar. So we'll start out with an introductory clause. So, if you've ever taken a look at a contract, at the very top of the contract, they're going to have an introductory clause, which basically provides the title of the document. We're going to call it an agreement or a contract or a service agreement, a professional services agreement. The title should give an indication of what the document is. You're also going to include in that introductory clause the parties to the agreement, and you're going to include some kind of an address for them. So if it's an individual, you're going to include their personal address. If it's a business entity that you're contracting with, you're going to want to include the business address. It's also nice to include a description of the type of business, whether it's a Connecticut limited liability company or a Delaware corporation. It's nice to include that in the introductory clause, although it's not absolutely vital. The next thing that we typically see are recitals. You might see some language that starts with whereas. You don't need to have the whereas in the front, but that is, traditional to include the whereas clauses. But essentially the purpose of the recitals is to explain in general terms the relationship of the parties and what the agreement is going to be for, like the purpose of the agreement. The recitals give the reader the opportunity to kind of read those recitals and like, okay, now I know that this is a contract for the provision of services, or this is a contract for the sale of goods. It just gives a little bit of background, enough background to give some context to what the rest of the document's going to provide. Typically, the next area that you're going to see in a contract are the definitions. And so, in a more simplistic contractual agreement, you may not have any like a separate definitions section, or you might have a short definitions section. But this is the area where you're going to take the time to define the terms that are important for your particular contract. whatever those terms may be. Um, if you are referring to maybe a separate scope of work, you might want to define that here. If you are referring to, if there's like requirements are an important part of your contract, you might want to define that word requirements here. So the definitions and that are going to be included in this section are really deal dependent and really depend upon the type of contract that you're dealing with. The next section is kind of, what is being purchased and sold here. We work a lot with professional services agreements of a variety of kinds. You can have like software as a service agreements. You can have, terms of service for a website. There's all different kinds of contractual agreements that you're going to have. And in each of those, you really want to be specific about what are you contracting for? If I'm the business owner and I'm selling, what am I selling? Am I selling my services? Am I selling this product? And you want to be specific in your identification of what you're selling and what is being purchased by your customer or your client. So you want to use a certain level of precision with respect to that. You don't want to be vague or ambiguous. And when I talk about being vague or ambiguous, you kind of want to be able to put this contract in front of anyone and have them understand what the two parties are agreeing to. And that's true of all of these terms. So you might be very intimately familiar with your own deal and what it is that you think you're agreeing to. But you want to make sure that there's no question about that between you and the party that you're contracting with. And a good way to determine that is to have someone who doesn't know anything about the deal look at it and see if they can understand what actually is being contracted for. The next section that we frequently see are like obligations or requirements. So, there might be client obligations. Maybe you can only provide the service that you're going to provide if your client actually provides you with some preliminary information. You, as the service provider or the product provider, you're also going to have obligations that you have to meet. And those obligations might be time sensitive, or they may not be time sensitive. But you want to really put some thought into, if you're the service or goods provider, what do you need from the client in order to give the client what they expect to receive? And you want to put some forethought into that so that you can include those items here in this section under the client obligations. So for instance, if you are providing a software program, but you need information from the client to begin, you're going to want to make sure in this section that you include language around a time frame for the provision of those requirements by the client, and you want to excuse your timeline, right? So if you have a deadline, you want to make it contingent upon the client actually providing you with what is required. If you're the provider of obligations, right, you want to try to obviously limit your exposure. So you want to include only those obligations that are necessary and that you're actually contracting to provide. And you want to be very specific about what your obligations are under the agreement. Because if you fail to meet your obligation, then that can serve as a basis for termination of the contract, potentially a basis for withholding of payment, and potentially a basis for termination of the contract. So you want to be careful about, and if you're the client, the same is true. You want to be careful about making sure that you're comfortable, that you can meet the obligations that are identified in any contract that you're going to be signing. The next area that's typically included in well, you absolutely have to include this in the contract, but this is the typical order. You want to make sure you include the price, obviously, and the fees, expenses, payment terms, invoicing. So are you going to have a fixed price, or is there some mathematical equation by which you're going to calculate the price for what it is you're producing or providing? And you want to identify specifically whether it's a fixed price or it's or it's other. And if there is some kind of a mathematical equation for the determination of the price or the fees that are going to be paid under the agreement, again, you want to be really certain that it is crystal clear, that that equation is crystal clear and understandable by both parties. And something to keep in mind here, not just with pricing, but with everything, is when you're dealing with a business, you don't know if the person who is your point of contact today is going to still be in that position 3 months from now, 6 months from now, as you're moving forward in your relationship pursuant to the contract. So you just want to be as precise as you can and as clear as you can with how your pricing is going to be determined. Expenses are another item. Are you going to be incurring expenses in meeting your obligations under the contract? And if you're going to be incurring expenses, are those expenses something that you take on as that business owner and cover? Or is it customary in your industry that those expenses would be covered by your client? And if you're the purchaser here, you want to think about, are they customary, and how do we define those expenses? Do I want to have the ability to pre-approve expenses before I'm obligated to pay them? We want to include language like reasonably incurred or reasonable expenses. Do you want to give the service provider or the product provider carte blanche to incur expenses? So these are some of the things to think about and to have conversations about, and then to identify in this written document what the agreement between the parties is with respect to incurring expenses and the covering of those expenses. You also want to include here your billing process, your invoicing process. Are you going to bill an invoice on 30 days? Is there just going to be one bill at the end of the service or when the goods are ready? Or are you going to do intermittent invoices? What are the terms of those invoices? How frequently should your client expect to receive them? Will they be payable in 10 days, 15 days, something else? Or will payment be due in full upon completion? Or are they tied to some other measurable goal? Perhaps you have a project where you're working in increments and you're going to be paid maybe a certain amount up front, maybe a certain amount with the first deliverable, a certain additional amount with the second deliverable. So you want to put some thought into your business, and how it is best for your business to receive payment, and in accordance with that as well, like what is typical in your particular industry. I wouldn't advise waiting until the end of the services unless that's what's typical in your industry. And then, if there's a failure to pay upon the terms that you set forth, are there going to be late fees? What are they going to be the repercussions for the failure to pay? If you are billing a client on an ongoing basis, you might want to think about retaining the right to suspend services in the event that there's a failure to pay. That's obviously going to be a negotiable point. Maybe your client wouldn't be agreeable to that, but you can see that these are kinds of the things that you want to think about. If there's a failure to pay, what are your rights? What can you do, and how do you kind of gain some leverage to get your fees paid in a timely fashion before you continue? Any of those terms you're going to want to include, again, with specificity in your written document in this section. The next typical area that we see is a term. So you need to define the term of the engagement. So if you liken it to a lease, is it a 5-year lease? Is it a 3-year lease? Is it a 10-year lease? How long? We're not talking about leases, we're talking about commercial contracts, but just to make the analogy. So how long is this contract going to last? This might be a situation where the contract's automatically going to terminate when the deliverable is delivered. Or it might be an ongoing relationship type situation. If it's not going to automatically be terminated, you might want to consider whether or not, or I'm sorry, you might want to define a term. Maybe it's a 1-year term, maybe it's 6 months. And then you want to think about flexibility. Do the parties to the agreement want to have some flexibility in extending that term? Maybe you're going to need more time. Maybe you include language that says the contract can be extended if the parties mutually agree. Maybe you give the right to extend it automatically to one person, but they have to provide some level of notice that they are extending it. Maybe the contract can be renewed. And what are the terms going to be of that extension or that renewal? And how will those terms be determined? Um, it is nice to have some notice of a client's intention to extend the term if it's their option, or to renew the term if it's their option, so that you can plan accordingly. And then any terms, if the price, for instance, is going to change in the event that the contract is renewed, do you want to define what that new price will be at this moment in time? Or do you want to include language that the parties are going to negotiate the new price at that later point in time? So these are kinds of things that you need to think about and account for. And when you work with an attorney, they're gonna take you through all of this and find out what your understanding of the agreement is, and kind of prompt you with some of these questions. This is just to get you thinking in terms of, when you're having these conversations and you're negotiating a deal, these are some of the things to kind of keep in your mind in terms of how you're going to negotiate and how you're going to come to an agreement. Because when it comes time for your attorney to draft the contract, they're going to be asking you a lot of these questions. The next thing that you want to talk about or think about is the termination. So, what are the circumstances under which the contract may be terminated? We talked about the term maybe automatically ending, but what if it's not going well? What if you need to terminate because the other party is not meeting their obligations? What if you're simply not being provided with the information that you need to be provided with? What if there's an issue between the parties over and above a failure to pay? You want to think about retaining the ability. You should always have the ability to terminate a contract for cause. Sometimes, depending upon industries, you might want to think about retaining the right to terminate a contract for convenience. Maybe something happens with respect to your business that it no longer makes sense for you to be engaged in a particular type of contractual arrangement. That would be, a circumstance under which you might want to retain the right to terminate for convenience. That can be a difficult one for a client to swallow, because they may be relying upon your services or your goods, but they may also appreciate the ability to terminate for convenience as well. So that can be something that can be a nice term for the parties to come to an agreement on, depending upon the circumstances. And then you want to just kind of think about what the effect of the termination is going to be. Typically, the relationship ceases, no more products are being provided, no more services are being provided. That is what and no more obligations exist between the parties, other than the next section, which is what's going to survive. So you could have a situation where you're terminating an agreement, but there might be obligations between the parties that survive. The most common one that I can think of is a responsibility to maintain confidential information. So not all businesses not all business agreements involve the exchange of confidential information, but some of them do. And you certainly want to think about confidential information if you have it, or if your if the other party has confidential information. So if one or both parties have confidential information and there's going to be an exchange of that information, you're typically going to have an obligation to maintain the confidentiality of the information. And that would be an obligation that would survive the termination. So that's what we mean when we talk about certain clauses survive termination, because it makes sense for them to do so. Or in the specific circumstances of the two parties to the agreement, it might make sense for certain obligations to survive. So that's something for you to kind of think about, also as you're negotiating. Okay, you can terminate if XYZ happens, but under no circumstances can you disclose the confidential information that you would have come into contact with during our arrangement. Um, this is taxes, is really dependent upon if you're the seller, what you're providing. But it is nice to think about the responsibility for the payment of the variety of different taxes that might be imposed on your relationship and how you want to allocate responsibility for the payment of those taxes. So there might be taxes on the sale of goods and the sale of services. And if that is the situation, then you want to include language here identifying the responsible party for such taxes. So you're going to want to think about that and provide that information to whoever is drafting your contract. The next thing to think about, and this happens a little bit more if there's a deliverable as opposed to just the provision of services. Title, like who has ownership? Who has ownership and when do they come into ownership? So if you have a business where you provide a deliverable to your client, when does the client take ownership of that deliverable, or do you retain ownership of the deliverable and provide the client with the right to use the deliverable? If you are providing ownership to the client, at what point in time? Obviously, not before they pay, but at what point in time do they take over ownership of the deliverable and therefore responsibility for the deliverable? So this comes up a lot if there's just a straight, sale of goods, and we're not going to go so much into the sale of goods because that's governed by Article 2 of the UCC, and I don't want to go too off track of what we're talking about. But there is risk in transfer, there's risk when it comes to goods and deliverables. So if they become destroyed at a certain point in time, who's bearing the responsibility for the destruction of those items? And some of that hinges on ownership, but not entirely. So this is very dependent upon the type of business that you're operating, but it's something for you to think about as you're negotiating your deal terms that you're going to provide to hopefully your attorney to draft this contract. You want to kind of think through some of these things, including like when are the goods or services considered to be accepted? If you as the service provider are providing a deliverable, do they have 30 days to look at that deliverable and make sure it meets the requirements of the contract? Do they have to notify you that it's okay that they accept? Are they deemed to automatically accept it as soon as it's provided? You have to think about what's typical in your industry and what works for your business. And then, obviously what the customer or client is willing to accept. And it's the same thing if you are on the client side, you have to think about what you're willing to accept and whether you're going to try to negotiate for some time to make sure that the deliverable meets the intended purpose and the requirements that you've kind of already agreed to. And then there's the effective acceptance. So what happens once you accept, and this gets us into warranties. So once I accept the goods or the services, am I stuck with them? What if something breaks down or the deliverable doesn't function at some point after I have accepted them? Is there going to be any kind of a warranty for the product or the service that's provided? If you're the service provider and you're providing warranties, you want to be very specific about the warranty that you're providing, and you want to disclaim any other warranties that you're not providing. But you want to, and you want to kind of have these conversations up front with, as both the client and the provider. You want to have these conversations and understand what warranties are expected of me, what warranties am I entitled to as the customer, and what warranties are being disclaimed. And then you're going to want to be very specific about those things. So, if it's like a software deliverable, am I providing a 60-day warranty? or is it going to be something longer than that? And if it's going to be longer, I'm going to specify what the length is and what the conditions are under which that warranty is going to have no longer be in effect. So if there's a change, right? Like if the customer takes the deliverable, makes a change to it, are you still going to afford that warranty? Is it a changeable deliverable, right? Maybe it's not. So these are some of the things that you want to put thought into when you're negotiating your deal. Indemnification is a really heavily negotiated area. And so I think it's advisable to have conversations at the outset and not wait until this gets to a point where your attorney's handling it. Although the attorneys could iron it out, hash it out. But you kind of want to have the conversation about, and the thoughts really about, and then the conversation, what do I want to be responsible for if something goes wrong? And what should the other party be responsible for if something goes wrong? So if you are providing a service, like with a deliverable that's going to be delivered, and there can be a claim by a third party for damage arising out of the use of that deliverable that you created. Should you be responsible for those third party damages, or should the party who you're contracting with be responsible for those third party damages? This is, as you can see, right, you're talking about covering losses, claims, and damages arising out of third parties. So this isn't a dispute between the parties, it's claims arising from anybody out in the world. So each party has a vested interest in negotiating for significant limitation here. And you have to make sure that you're trying to negotiate for the coverage that would be typical in your industry, and the coverage that's going to be most fair to you in the position that you are in the contractual relationship. And you want to be cautious about what the indemnity is being provided for, right? So who's providing the indemnity and what's it being provided for? Again, this is a heavily negotiated area, and can become a bit contentious. But I think it is helpful when you are negotiating your deal to, again, like keep in mind what's standard for your particular industry. And being mindful about what could possibly come, and being mindful about problems is something where your attorney can really kind of help you. Confidential information, we touched upon this earlier, and not every business has true confidential information, but you'll know it if you know it if you do, right? And you want to kind of, this is one of those defined terms that you're going to include in your definition section, like what is confidential information? How do we characterize that? And then what are going to be the obligations of the parties in the handling of the confidential information? Obviously, they have to have a duty to not disclose the confidential information. Either party in a contract would want their information that they're providing as part of, needed as necessary, right, to get the services. They're going to want that information to be protected. They're going to have an expectation that that information be protected. How much protection is sufficient protection? Some of that depends upon, again, the type of industry that you're working in. And then there's usually going to be a responsibility imposed for a breach, or a failure to hold that information confidential. This is going to be, again, like a heavily negotiated provision, but incredibly important, and very industry dependent. Your representations and warranties, this is usually something that's, a section that's included in a contract. So the representations are statements of fact, and the warranties are statements of assurances. And so this is really an area that your drafter, your attorney, is going to pay a lot of attention to. And, not so much necessarily going to be a point of negotiation. But it's important to have an understanding of the significance of the representations and warranties um, overall as you're negotiating part of the contract, because there's going to be an allocation of risk here. Um, just like an example that's easy that comes to my mind, but easy for you to understand would be a situation where we're dealing with like maybe we're developing software, like maybe you're a software developer and you're going to be receiving existing software from your client and you have to make changes to it. Um, so you need to make sure that there's no issues with the ultimate deliverable, but you shouldn't necessarily be taking on responsibility for part of the product that you're receiving from your client. So you're going to want to have them give you some assurance that they have the right to use whatever it is that they're providing to you, whether it's software, whether it is a trademark, whether it is, just a widget. They need to provide you with assurance that they have the right title interest to go ahead and provide you with the ability to use that product. That's just one example of the importance of an assurance and kind of giving an example of what an assurance is. Because what it does is it allocates the risk between the parties. Okay, later, these representations and assurances can be used as a basis for a breach of the contract. So, if a third party comes out of the woodwork and they want to sue for a misuse, for example, or an infringement, um, you're going to want to go back to your contract and say, okay, so and so, you provided me with this assurance that you had the right to afford me the opportunity to use this product. And now it turns out that you didn't. So we're going to sue you as part of this contract and you're going to be responsible for um, these damages that are being claimed. It's a really simplistic explanation, but I'm just trying to give you a flavor for the importance of this section. And this is, again, another heavily negotiated area between attorneys because you, as the attorney, you want to limit exposure for your client. And so you're trying to limit the representations and warranties that your client's going to go ahead and make. Insurance is another area where the attorneys typically get more heavily involved and the clients don't necessarily have their mind on insurance, but you do want to be mindful of coverage for your own business, whatever it is. Obviously, you want your own coverage, but you do want to be mindful of, to the extent that you're relying upon your client to cover you for certain types of claims, you want to make sure there's insurance in place for those types of claims. So commercial general liability insurance is a really easy example. If somebody is coming onto property and they end up slipping and falling and sustaining an injury, somebody has to be carrying insurance for that. That's just an easy example of insurance. And again, this is another area where the attorneys are going to become heavily involved in. But it's important to understand the significance of insurance because you want to have an outlet for coverage in the event that something goes awry. Force majeure used to be much more typical language, right? Force majeure just means like if something happens that the parties aren't expecting to happen that prevents one of the parties from performing, is that event that occurs going to excuse the performance of that party? If it does excuse the performance of that party, then you can't sue for breach or failure to meet the obligations under the contract. So before COVID, this language was fairly standard. And now since COVID, and we saw, everything shut down and things that people previously never anticipated before occurring, the force majeure provisions are a much more heavily negotiated area than they used to be. It used to be fairly standard language. So again, this is something where your attorneys are going to become involved. But you want to be mindful of the circumstances under which you might be willing to excuse performance from the other side, and the circumstances under which you might want to be excused from performance. You're not going to have carte blanche here typically to account for every possible contingency, but the ones that are very important and problematic for your industry might be something worth negotiating for. Limitation of liability is really, it is important. And again, I think the attorneys are going to get more involved here than the clients, but in understanding the significance of it, a limitation of liability is exactly what it sounds like. It says, the party's going to be responsible for damages if something goes wrong, but we're going to be limited in the amount of damages we're going to cover. And often in recent years, the limitation of liability attempts to limit damages to the value of the contract. And so you just have to kind of be mindful of these types of provisions when you're negotiating, because things can happen in the context of a relationship that far exceed the value of the contract. And you want to be careful and work with your counsel on thinking about these things and being careful in what you're willing to agree to for any kind of a limitation in responsibility or liability. The next thing that I have here is like miscellaneous. So there's always just kind of standard language that we typically include in contracts. Notice. So again, a lot of these are, the things that the attorneys are going to get involved in, but it's important for you as the business owner to understand what you're negotiating and agreeing to. So, typically you want to be provided with notice under your contract. Please provide notice in the event that there is deemed to be a breach. And you have to define, the type of notice that's sufficient. It should, obviously it's going to need to be in writing, but do you need to mail a letter? Is email sufficient? You need to include addresses, the ability to update those addresses. Assignment. An assignment occurs if one party or the other wants to assign their rights or interests in the agreement to another party. And the ability to assign an agreement or not tends to be industry specific. But you want to think about this in terms of who am I agreeing to do business with? And do I want the party that I'm agreeing to do business with to have carte blanche to put me in a business relationship with a third party? Or do I maybe want to be able to approve of that transfer of my responsibility or obligations to that third party? Successors and assigns. So whereas assignment is, transferring the contractual relationship to a third party outside of the relationship, it's typical to allow the contractual relationship to transfer to a successor of your business. Waiver and breach, we usually include some language that even though you might waive your right to pursue your remedies for a breach, it doesn't mean that you're waiving your rights in total. So if the same breach occurs, you can go ahead and enforce it at a later point in time. Merger. So every written agreement should include language about merger, and it's important for you as a business owner to understand that this language is likely to be included in any agreement that you sign. And the significance of it to you is that the language says there are no other agreements between the parties other than what is in this writing. And if you take nothing else from this presentation other than this, I will consider my time well spent, because it is constant that, there's two parties, they're talking, they're trying to come to an agreement, they're negotiating, and they walk away with different ideas of what they've just agreed to. And one party will come to the attorney and say, well, they told me that if I did this, they're going to go ahead and they're going to throw this in and they're going to throw that in. And when you get the written document, those things that were supposed to be thrown in are not in the written document. So what this merger language says is whatever they told you during negotiations is irrelevant. It doesn't matter what they said, because if it doesn't make its way into this written agreement, then it doesn't count. So you want to be really careful, and when you're entering into negotiations, like literally write down what you think you're getting and share that with your attorney so the attorney can make sure that what you think you're getting, you are actually receiving in the written document, because you're not going to be able to go back and say, well, he said, she said, because that's what this language prevents. Written modification, there should be language in your written agreement that says it can't be modified except by a writing signed by both parties. So the same way that the prior conversations become irrelevant, your subsequent conversations are not going to be binding on this agreement, because you're going to have language typically that says that they're not binding unless they're in writing. So it protects both parties. You can, again, you're in the course of your relationship, something comes up, you agree that something needs to be changed. Unless you reduce that agreement to a written document signed by both parties, is not going to be enforceable. So if there's, like, use it in terms of like a change order, and your client wants you to do something differently, and you say, I can do that differently, but it's going to cost more money, and they say, okay, you need that to be in writing, and you need both parties to sign it, or otherwise you're not going to necessarily be able to be paid on that change pursuant to the terms of the contract. Choice of law and venue. There's going to be language that identifies the law that applies to the agreement. And you want to be mindful of where you're doing business. So if you are a Connecticut company and you're doing business exclusively in Connecticut, and this is where your offices are, but you're contracting, maybe you provide services, you're contracting with someone in Illinois, you as the service provider are going to want to be governed by Connecticut law. And you're going to want, the venue is where any litigation that arises between the parties would be taking place, and you're going to want to be that, and you're going to want that to be Connecticut. If you're a Connecticut company, your Illinois client is going to want Illinois law to be governing, and they're going to want to litigate any issues in Illinois. It makes it simpler for the party to have, and less expensive for the party to have their own state's governing law govern the contract, and the venue to be in their own state. So this is something that the attorneys will pay attention to, but you're going to want to be mindful of that as well. If you're dealing with, clients that are not inside the state. Severability is just kind of standard language where we say if any provision, of the contract is found to be unenforceable, it doesn't affect the enforceability of the remainder of the provisions. I've waiver or breach here twice. Counterparts, you want to make sure, and the attorneys will do this for you, but counterparts in electronic signature, nobody's sitting in a room together anymore signing a document. You're going to sign one piece of paper, your client is going to sign the other piece of paper. So you want to make sure that you have language that makes that okay. And more, we're seeing electronic signatures. You're going to sign and you're going to send a PDF, other than real estate. You're going to sign and you're going to send a PDF, and that's going to be binding, but you want to make sure that there's some language in your agreement that affords the ability for electronic signatures to be accepted. And again, your attorneys will make sure that language is included. That's very standard language. Then you're going to have your execution, your signatures. So it's incredibly important, if you have a business, that you are signing all of your contracts in the name of the business. And you, as the manager or the member of the business, or maybe the president of the business, as the case may be, you don't want to be signing a contract that is for the benefit of your business in your individual capacity. So you want to make sure that the signature block is set up so that it has the identification of your company, and it has your signature and your title that identifies how you're signing that document. Again, whether you're signing it as member, manager, president, etc. and you want to make sure that the same is true. You want to you want to have some level of assurance that the party opposite you who's signing has the authority to sign that document. Then these are just other items to consider that I didn't go into because they're very industry specific. So if you're dealing with a business, if you're in the business of dealing with, or the other parties in the business of dealing with personal identifying information, there are going to be a lot of provisions over and above that are going to be really important to include because there's large responsibility and liability for failure to protect personal identifying information, cyber issues, breaches, etc. So if you are dealing with that kind of information, you're going to want to be mindful of those things. If there are multiple parties, you need to think about when you're negotiating the interplay of the different parties, the responsibilities of the different parties, and then the potential liability for the different parties. If you have foreign parties that you're dealing with, that's a whole additional thing, a whole additional consideration that you need to be mindful of and having conversations with your attorney about that. Intellectual and property is also another item that you're going to want to be mindful of. If you're dealing with any intellectual property at all, you're going to want to include you're going to want to have your attorney be aware to include a lot of additional language around, any kind of intellectual property. So that concludes, just my outline of the things, for you to have consideration of in your negotiation and conversations with your attorney, and in your own personal review of documents before you sign them. I just want to make, sure that you understand that I'm not, providing this information for you to go out and draft your own contracts. I definitely advise against you drafting your own contracts, but I do think it's important for you to understand in reviewing contracts what these sections mean. And then in your review with your attorney when they're negotiating, it's important to understand why the significance of each of this of these items so that you can understand maybe the perspective of your attorney and how important it is to push back on certain things and where you can negotiate certain things. And at this point, I don't know if there's anybody on that might have any questions. I'm happy to answer some questions if there are any.
I'm checking the chat right now. Well, first and foremost, excuse me, I just want to say thank you. This was very informative. I learned so much. I caught myself taking notes on certain things.
Thank you.
So that really, I know this is definitely going to be beneficial to people watching. There aren't any questions in the chat, but I guess I have a few questions of my own, just by
Sure.
taking notes and just digesting everything you're saying. So you just stated at the end that you don't want small business owners drafting their own contracts. So I guess the question that I have is, what are some of the common mistakes that you see small businesses making when they're drafting their contracts?
That's
And
good.
how can they avoid doing that?
Well, one of the mistakes that they make is in their execution of the contract and signing it in their individual capacity as opposed to their business capacity. Another area where they make mistakes all the time is not understanding the significance of the written document and the merger language that I just mentioned, and the significance of that, because I think, you're out there, you're conducting your business, you're trying to come to a negotiation and agreement, you want to get things done, and you want to take people at their word. And I'm not saying you can't take people at their word, but if there becomes an issue, you want to have something to rely upon. And so I think that business owners commonly think that what they've agreed to orally is the agreement, and they don't shore up the inclusion of those terms in the written document that they end up signing. And then
Mm.
they say, okay, I didn't realize that that wasn't in there. I thought that that was a given. I think another area where they make mistakes is, we call it vague and ambiguous, right? And that's just like this generalized language that lawyers like to use, but confusion. What you think is clear in your mind is not necessarily clear to the other party that you're contracting with. And it's all fine as long as everybody's playing nicely in the sandbox. But as soon as something goes awry, somebody's going to rely on that ambiguous language to advocate for their position. Well, I understood it to be this way. And you're going to say, no, obviously it's this way. But if two parties can read that language and not have the same understanding of it, it's a problem. So you need to make sure that it is super clear. And again, like what might be clear to you, Kobe, is not necessarily what's clear to me. And I think having like open conversations is really helpful. But that written document needs to be clear. And I think that there's a lot of ambiguity in the contracts that business owners ultimately sign. I think that business owners make common mistakes and kind of not maybe, I don't want to say that they overpromise, but they're not clear about what they're promising to do. So it's another ambiguous area, but I think they make a lot of mistakes in failing to be specific about what they're agreeing to do. And the other party, who's maybe the client, what are you buying? Like, does this document that you're signing actually give you what you think you're buying? And like, I think another mistake is, let me think about this. Probably the ability to get out of the contract, like terminating the contract. Like, I think that everybody just thinks, well, just terminate it. If it's, I can terminate it if it's not going well, I can terminate it if they don't pay, but can you? Like, can you? You really need to be specific about the circumstances under which you're going to be able to get out of this relationship if it goes awry. If it goes badly, you want to have some foresight and some thought about, geez, if this happens, I want to be able to get out of it. And I think that if you're a business owner and you've been in business for 5 years and you've probably gotten yourself into enough jams where you can, like, you learn, right? You learn through problems. I mean, unfortunately, but you don't have to learn through problems. You can, talk to an attorney, and the attorney can tell you where you are going to potentially run into trouble. So these are like some of the areas that I think, small businesses, when they kind of enter into their own agreement, they get into trouble.
Okay. No, that's really good.
Yeah.
And you actually bring up another great point for my follow-up question is, when exactly should a small business owner bring in an attorney and legal counsel to help out with drafting these contracts and looking over?
I don't think any time is too late to do it, but I think at
Mhm.
the outset of your business is really nice, because what you can do, what I do for clients often is come up with a template
Mm.
that you can use for all of your clients, depending upon what your business is. I mean, almost every business can come up with a template contract. And then maybe you're going to negotiate certain terms, like certain clients might ask for certain things, which you as the business owner can negotiate. And then maybe you ask the advice of counsel for the language to mirror the negotiated point that you met. But I don't think it's ever too late. If you're in business for 5 years and you've been using a contract and it's going great, I wouldn't say that means you shouldn't involve an attorney, but I think it's easiest for people if they involve someone at the outset. Having said that, it can be financially problematic, right? I think this is why people, you want to go to the internet and you want to pull a contract off, and you're like, oh, I can do this. And I had a client recently who came in with he's a really good example. And if he ever watches this, he's gonna know I'm talking about him, but he came up with this agreement for himself. And the problem with it was very detailed, but he was the service provider and he didn't realize how client favorable it was. He
Mm.
was giving away the farm and he didn't have to give away the farm. So when he finally, got me involved, I was like, well, why are you, let's reel this back some, because you're making promises you don't have to make. You're giving warranties that you don't have to make. Like, let's get you some more, and you're not protected in ways that you should be protected. So let's kind of bring this back. So I think that if you don't have any understanding of some of these things, it's easy to pull a contract off of the internet and then overpromise things that you don't need to overpromise and kind of get yourself into trouble that way. It is not as easy as, Zoom, like legal, whatever it is, might make you all these online programs. I don't even remember their names anymore, but like it's not as easy as they might make it seem. Because if you work with an attorney, they really do try to craft it to what you're doing. And if you work with an attorney who's mindful of new business or small business, they're going to try to give you a template and not recreate the wheel every single time you enter into an engagement. That's a
Okay.
long, really long answer. I'm sorry it took so long.
No, it's all good. No, I think it's good because you're pointing out the steps that it takes to do that. Like I
Yeah.
feel like a lot of people they just jump into it, and it might be until they get a notice that says they're getting sued that they're like, oh wait, now I need to bring a lawyer in to look over and protect me.
Right.
But
Or they get into trouble where, somebody refuses to pay a bill.
yep.
They get into some kind of trouble and then they're like, and then that makes them say, oh, okay, maybe there's a problem here.
Mhm.
Usually if they get into some kind, maybe they're not sued, but they're having a disagreement with a client and then they realize that maybe they need some more protection. But to the extent that the earlier the better, I would say, for involvement with an attorney.
Okay. So how often should these individuals should they review their contracts and update them to make sure that they're in legal compliance with everything going on?
I mean, I think that if you have an attorney drafted at the outset, then I think that you don't necessarily have to review it incredibly frequently for compliance with law, but you're going to, as you operate your business, you're inevitably going to encounter scenarios that you would have never anticipated, right? Like you can't anticipate every potential problem that's going to go wrong. And so, you might want to do like just a yearly check-in.
Mhm.
Um, and to the extent that you've had some issues arise in the past year, and kind of like, keep track of what you're seeing as presenting as problems, and then and then maybe you meet with your attorney maybe once a year, or if it maybe you want to head it off. If it's a huge issue, you might want to head it off, but maybe yearly, and just say, everything's working well, or actually I'm having people like not pay me on time, and maybe a late fee would be helpful to getting them to pay, etc. So I would say have some mindfulness about what your issues are
Mhm.
throughout the course of a year, and then maybe have like a yearly, conversation. Doesn't have to be long, doesn't have to doesn't have to cost a lot, but I would probably suggest yearly.
Okay. No, that's perfect. Like I said before, I think this is really great. Everything that you're talking about, it's really important. And the one thing that I really want a lot of small business owners and entrepreneurs to understand is the the power that having a good lawyer on your side, what it does for you, right? It gets you out of certain jams, it
Yeah.
protects you. There are liabilities in everything in business. Like business is like the liability industry, but you have to make sure that you protect yourself and you surround yourself with people who care about the well-being of yourself and your business and are willing to, just make sure that nothing bad happens to you.
Yeah, I mean, I think that it's important. Like I look at my role working with businesses as like part of their team, and it's kind of helping them, anticipate, right? Like helping them anticipate what might come up and what might arise, and trying the best we can to protect against problems. But again, you can't anticipate everything. There's going to be things that are going to occur, but it's nice to have somebody that you trust and that you can reach out to when something arises, and figure out a way to avoid that, like avoid
Mhm.
that in the future.
Well, I guess one more question. If someone has like any questions, like how can they reach out to you for assistance if they need it?
So, I'm pretty sure, well, my contact information was included on the advertisement for this program.
Mhm.
But I'm on the website of our law firm also, so you can just, look for my name or just Google me, and just give me a call, and I'm happy to have a conversation with anybody and find out how I can help.
All right. Well, thank you so much. I really enjoyed this. I
Thanks.
was
Okay.
really excited when we first met, and I said, you know what, law is something we need to discuss a lot more in the small business industry in this ecosystem. So I'm glad we were able to just to get a little bit of what these entrepreneurs and small business owners can do to protect themselves from liabilities, depending on which industry they're in. So
Yeah,
I
no.
truly thank you for that.
Thank you so much. It's been fun, and I appreciate the opportunity to, if I can, help anyone, then it's been, I really value that. So thanks for the opportunity to do that.
Well, thank you. Thank you. Well, again, thank you to everyone who tuned in to our small business support webinar series. I'm Kobe Smith here with Patricia DeLeo, and I'm just very excited we're able to talk about this and see how small business owners can draft up contracts and what are the tips to making successful contracts that can help them with their business. So thank
Right.
you all for tuning into
All
this.
right. Thank you so much.
Thank you.
All right. Bye-bye.
All right.